All right. So hello, everyone. Thanks for joining. My name is Courtney Ernston. I'm with Midwest Business Law. We are here talking today about the St. Matthews versus State Farm case, which I'm sure a number of you have heard about that just recently came out. And so I just wanted to give you guys a little bit of information as to what we know now and what you guys should know and what you should do moving forward. Now, I do want to preface this with saying, I am an attorney for contractors, okay? I am not an insurance specialist by any means. And so to the extent that you guys have questions about, specific policies and ACVs and RCVs and all of that kind of stuff, I'm not going to be answering any of those questions. So if those are your questions, I will defer to the insurance experts on that. So I just wanted to let you guys know up front about the policy stuff. So with that, let's hop in. So just kind of a little bit of background on what happened in this case. So the St. Matthew's Church in June of 2017, there was a wind and hailstorm that caused some damage. Part of the damage was there was an exterior drywall was damaged in the storm. It was a common masonry wall between two low slope roofs. And the wind and the rain caused the drywall to be damaged. Now, State Farm in this storm agreed that they would cover the cost to replace and repair or remove and replace the drywall, the damaged drywall. Now, as I'm sure you guys all know, once they removed the drywall, they got in there and they found out that the underlying masonry was cracked. And so, of course, the city would not allow them to fix the drywall unless they replaced or fixed the masonry underneath the drywall. And so State Farm said, we're not going to cover that because that wasn't damaged in the storm. St. Matthews then demanded an appraisal. So they filed a lawsuit, compelled appraisal. The appraisal, oops, I don't want to do that. The appraisal panel then said, yes, the masonry should be covered. And so they offered to pay, the appraisal panel awarded $77,969 to have that masonry on top of the work that was already approved by State Farm to have that fixed. However, the appraisal panel also determined that the masonry was, quote, deteriorated conditions and the cracks and out of plumb conditions were not caused by the storm, aka they were pre-existing. So after the appraisal panel determined, yes, State Farm, you need to pay for this, but no, the masonry was not caused by the storm, State Farm then went back to the courts and said under Minnesota statute 65A.10 that they're not required to pay for that work because it was not caused by the storm. So the court then granted summary judgment and said, yep, you're right. Because if we look at 65A.10, which is on the screen here, this is the statute that most of you probably either directly or indirectly know about, which is essentially the code upgrade provision in our statute. And so what this statute says is that if the insurance company has to pay for replacing, rebuilding, or repairing lost or damaged property in accordance with the minimum code as required by state or local authorities. Now, there's two different provisions here within this statute. So the first one talks about a total loss. And so if the event caused a total loss, then whatever needs to be done to bring it up to code compliance is required. Now, the second part of this statute is what State Farm focused on, which says in the case of a partial loss. And so here we've got a wind hailstorm, which caused, damage to the roof, siding, a couple of other things. And so this is a partial loss. And this statute says, unless more extensive coverage is otherwise specified in the policy, this coverage applies only to the damaged portion of the property. And that's the part that State Farm focused on, was the damaged portion of the property, bringing it back to the covered loss. And so the district court granted summary judgment and said, you're right, State Farm, you don't have to cover the masonry because this is not, the masonry was not damaged by the storm. That then went up to the Court of Appeals, who agreed and affirmed and said, yep, State Farm, you don't have to do that. And then it went to the Minnesota Supreme Court, who just recently issued this decision little less than 2 weeks ago. Now, at the Supreme Court, St. Matthews argued that the masonry is covered because, as I'm sure you all know, in order to fix the drywall, the masonry has to be fixed, because that's what the city's not going to either issue us a permit or sign off on the permit unless that work is done. State Farm argued that the damaged portion is covered, aka the drywall, but the masonry is not damaged, therefore it's excluded. And the Supreme Court ultimately also agreed with State Farm and affirmed. Now, so that's kind of a lot to unpack, but basically at this point, the Minnesota Supreme Court has said that under these facts, State Farm was not required to pay for this masonry. Now, here's where things get a little tricky, and also where I know most of you get very irritated with attorneys, because this isn't necessarily a bright line rule. Now, one of the things that the Supreme Court said in their opinion, and this is I think where a lot of the confusion is going to come in the next probably couple of years until this is clarified. So what they said is that our opinion is limited to this particular context in which the drywall itself could be completely replaced in compliance with the code without making any additional changes to other parts of the property, and whether 65A requires the insurer to cover the cost of fixing code violation is a fact-intensive inquiry. Now, in this opinion, it's very interesting because there was a dissent. Now, in a Supreme Court opinion, so there's what's called the majority opinion, which is what's adopted and ultimately becomes the law, and sometimes there's a dissent. And in this case, 3 of the Minnesota Supreme Court justices joined in this dissent. And I think that the dissent in this particular case is going to drive either policy change in the legislature or is going to assist you guys in some of the issues that you're going to run into as a result of this. Now, ordinarily, I wouldn't get in too much to languages of Supreme Court cases because sometimes they're very verbose and legal. But in this particular dissent, I think that it's very, very important for you guys to understand some of the language that was said. And so I'm just going to give you a couple of the highlights. In this dissent, Justice Hudson wrote the dissent, and she said that the statute 65A is ambiguous because when it talks about what the damage is, we have the case like in St. Matthews where the damage to the wall, I mean, in the dissent, a wall, is what the Justice Hudson said. And she's confused because the majority says that the drywall could have been fixed, but the masonry wasn't necessary because the drywall independently could have been fixed. She essentially says it's a very convoluted argument and way to get to the idea that State Farm doesn't have to pay for the masonry fix. And then she talks about public policy arguments, and these are the things that I think are not only incredibly insightful and spot on, but some of the things that I think you guys are probably thinking about as well. So she talks about some of the public policy concerns. And one of the things she brings up is that in adopting this view, this very narrow view of the code compliance, she says that it's going to be more difficult for property owners to bring their property up to code following a covered loss that leaves the possibility that code violations will not be fixed. Public policy supports incentivizing insurance coverage for repairs that will remedy building code violations. That's the whole reason that we have 65A, is because if there is a building code violation and you're paying for insurance, it should be covered. And so she says it doesn't make sense that we have a statute that requires code compliance, and now we're nitpicking essentially what is going to be covered and not. The second part that she brings up with public policy, and I think this is for you guys going to be probably the biggest area of headache that you're going to run into, is not everybody has the money to bring up their property to what code would be. And so if they don't have the money to bring up code compliance, even though they're buying insurance, where's that going to leave everybody? And we'll talk on that in a little bit, but I think that, in my opinion, is one of the first things that was concerning to me when this case went up to the Supreme Court initially is, what's going to happen if the insurance companies are allowed to make these denials? She also talks about, this idea that the majority says that it's a fact-intensive inquiry, and kind of gets to, this confusion of, well, how is it that the drywall and the masonry can be separated, but in this exact case, State Farm agreed to cover the roof decking and bring the decking up to code because State Farm said, well, the decking is a part of the roof system. And so she goes on to say, how is it that the decking can be part of the roof system, but the underlying masonry cannot be part of the wall system? So she just is, basically like, where does this end? And that kind of ties into her last point, where she says that she's very concerned that this rule will encourage insurers to adopt an infinitely narrow view of the damaged portion of the property under 65A and seek to divide a single structural element of a building into increasingly smaller parts and subparts and sub-subparts. That's directly from her opinion, and I think that that's exactly what's going to happen. I think that she's spot on, is that we're going to see insurance companies now saying, well, based on St. Matthews, we can now, now the masonry is not part of the wall. So then does the outlet that goes on top of the drywall, the list goes on and on as to how this is going to happen. And as I'm sure you guys all know, insurance companies are going to do anything that they can to avoid having to pay for any of these upgrades. And so this decision is confusing. It does not necessarily go in line with what the statute says. And now we've got insurance companies that have a legally binding court authority saying that they can deny. So of course, the question is, what does this mean? Now, as it stands, this is now the law. So one of two things could happen in order for this to change. Either the legislature could act, they could amend 65A, and this is one of the things that you guys as private citizens, I would encourage you to do is contact your state legislatures and say, hey, this is going to be disastrous for Minnesota homeowners because now the insurance companies, as Justice Hudson said, is going to say this is a subpart or sub-subpart or sub-subpart to try and avoid having to pay for this coverage. And so I think that that's something that I would encourage you all to do, is to have this statute clarified as to what is covered and what is not covered. There also could be a new case that would go up to the Supreme Court where they would either overturn or clarify the St. Matthews case. Now, in both instances, as I'm sure you all know, that's not a fast thing, right? So this is something that, at the very earliest would be maybe 2 or 3 years from now if the legislature decides to act. If it goes up to the Supreme Court, that process is sometimes in excess of 4 or 5 years. And so that's not going to happen anytime soon, unless there's a very, very similar case that's kind of currently making its way up through the court, which I highly doubt, but it could happen. So as I kind of alluded to earlier, obviously the insurance companies are likely going to deny more and more claims, and they're going to amend their policy declarations with their homeowners to exclude a lot of this stuff that we're talking about, or to be very, very specific about what's covered and what's not covered, what will be included in the code upgrade and what won't. Now, this is kind of taking a step back from the St. Matthews case, but again, as an attorney for contractors, one of the things I feel that I'm often having to remind you guys is that this is not your fight. Now, I know it is your fight because you have the contract and you're doing the work and you want to get paid, and so you take it on as your fight. But remember, your contract is with the homeowner or the insured. The insured has their contract with the insurance company. And I see a lot of times contractors, they'll call me up and they'll say, oh, this homeowners, they're getting screwed over by their insurance company, and what do we do? And we got to fight and blah, 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 blah. It's not your fight. And not only is it not your fight, but you can get in trouble for fighting that fight. And so just be aware of what your responsibility is and what your role is in these projects. Now, I get it. That's the industry. That's how it works. That's how it's been done. And I understand all of that stuff. I just want to emphasize and stress again to you guys that if you are a contractor, this really is not something that you need to be taking on if you do things the right way, which we'll talk about in just a second. Now, one of the things you can do, is provide your homeowners with resources. And so they may need to, you might see the uptick in the need for public adjusters or for appraisal panels, or for even to have to hire an attorney on the homeowner to hire their own attorney, not you guys, to fight on their behalf for some of these denials. And the problem is, which I'm sure you guys are all thinking anyways, is, well, they don't want to fight. And if they're not going to fight, then I'm not going to get my money. And so I have to fight. I get it. I get that's how things have been done, but that's not something that you guys need to be taking on in your fight. And the way that you do that is stop doing insurance contracts, stop doing as per contracts, do a fixed price contract. Some of you may be in the Level the Playing Field Facebook group, and one of the things that Steve Patrick talks about over and over and over is stop doing as per insurance. If you are in this business, you should know or should be able to provide a bid. How much is it going to cost your company to do this work? And make sure that you've got a good margin in there. I understand things come up. There may need to be change orders, all of that stuff. But if you do the fixed price contract, you're not tied into this insurance fight, right? Because what you say to the homeowner is, I'm going to charge you $25,000 to do your roof. If you get $24,000 from your insurance company, or you get $28,000 from your grandma, or whatever, I don't care. That has nothing to do with me. I am owed $25,000 for this work, and however you get that money, that's your call. That has nothing to do with me. And so I'm really, really pushing for a lot of you contractors to stop doing the as per and to start moving towards kind of how it used to be, which is the fixed price contract. Now, I'm sure most of you aren't going to do that. So some of the ways that you can, again, try and protect yourself in light of this case. Pre-signing inspection. This is huge, 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 huge. One of the things that you guys should be doing is go look in the attic. Take your flashlight up there, look at that decking. I mean, are we seeing water stains? Are we seeing big spaces? What are we looking at? Are we, there are so many things that you can tell just by doing that visual inspection. Look at their electrical panel. If their electrical panel is from 1940 and you know that you're doing siding and there might need to be some rewiring done, is that going to now be denied or is that going to be covered? We don't know. But by doing the pre-signing inspection, you're arming not only yourself and the company with what are some of the potential costs that could come up here, but you're providing your homeowner with this information before it comes up. I mean, I'm sure you all know that by being able to anticipate these things, the homeowners are far less, at least shocked. I mean, they're still probably going to be pretty pissed if their insurance company isn't paying for it, but at least it's not this huge shock to them that they may need to cough up some dough. And that kind of goes hand in hand with the next point, which is explaining the hard costs. Now, I'm sure in a lot of your contracts, you have something like, oh, if we have to redeck, it's going to be, $12 a sheet or whatever you have, some sort of generic number, but it's a real small number. And so explaining those hard costs, you do the inspection, you see that it's very likely that this roof is going to need to be redecked. and you have that conversation up front with your homeowner. And so by saying, hey, I just want you to know there's this case that just came out, and your insurance company, I don't know what your policy says. I'm not going to look at your policy because I'm not a policy expert. That's not what I do. I'm a contractor. I build shit. So that's not going to be your job. So again, stop trying to be insurance experts and interpret things and these policies, because it's never good. But then you're able to say to your homeowner, hey, there is a possibility here that your insurance company might deny it. And if that's the case, I want you to know that this could be a $6,000 out-of-pocket expense. And we, as the contractor, are not going to be able to put on your new roof until we have this redecked. Do you have $6,000 out of pocket if this comes up? Does your company offer financing? Maybe this is a good time to bring up your financing program, where you can explain to them, hey, we just want you to know that if this does, we do offer financing, yada, 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 get things rolling. But the communication about what these hard costs have the potential to be is going to be, again, a much, much easier conversation to have than springing them with, oh, well, you signed the contract and it said that, it was going to be X dollars per sheet. I mean, you should have known. They don't know. They don't know what that means. And so explain what those potential hard costs up front could be. And then this is going to be something that, the industry itself is going to kind of have to figure out. I've actually been in conversation with some people at the Department of Labor, because, what I anticipate happening is you get into a project, you've got it all torn off, you find out that something needs to be upgraded or changed, the insurance company denies it, the homeowner doesn't have the money. So what do you do? What do you do? Do you take the loss as a company and you continue the project and finish it out? Do you say, F it, throw a tarp on there and walk off? I mean, we don't know. And so you guys are going to have to, as companies, figure out, okay, it's likely that something like this can come up. Have a policy in place before it comes up, so that you guys aren't scrambling and trying to figure out, well, what should we do? What should we do? What should we do? And know that whatever policy you pick, there's going to be problems, right? So if you choose the tarp it and we're out of here because, we're not paying for your decking, what are they going to do? They're going to bitch online. They're going to go to the Department of Labor. They're going to do all these things. And so, you have to figure out as a company, what is your policy going to be? Make sure that that's communicated to everybody and that you stick to it. Now, you may have a policy and be like, oh, we picked the wrong policy and change it up. That's totally fine. But my point is that, in light of this decision, you guys are going to need to really kind of brainstorm amongst yourselves and figure out, what are we going to do? Because there really is no right answer. Unfortunately, I don't have the golden ticket for you guys. And then the last thing that you guys can do, obviously, which this should be throughout every project, but particularly with this kind of stuff, communicate and document. If you're doing the attic inspection, take pictures. Make sure that you take your pictures, and then make sure you upload those into your AccuLinks, or that you give them to somebody so that you've got the pictures. Give them to your homeowner. When you're having that conversation about those hard costs, hey, here are the pictures that I took of your attic, and and then guess what? There's your upsell. Oh, by the way, your insulation is looking really, really bad. Are you noticing it's really cold in the winter? Now might be the time to do insulation. Oh, and since you're going to have to do the decking anyways, you might as well finance the insulation project too, and we'll give you 10% off. I mean, you guys know how to do this, but communicating and documenting is going to be big. And, quite honestly, I don't envy the situation that you guys are in. Obviously, insurance is getting more and more difficult. The insurance companies are getting tighter and tighter. And so, that kind of brings me back to my first bullet point here, which is, stop doing as per insurance, because that's really the only way that you guys are going to get out of this cycle that everybody seems to be in. So that's kind of the overview of what we had. I see that there's a question here. Are you of the belief that the insurance companies will now start attempting to deny decking upgrades, even though the decking is part of the roofing system? What I'm saying, Kyle, is that we don't know. And what I anticipate the insurance companies are going to do is, again, as Justice Hudson said in her dissent, they're going to try and narrow down as much as they possibly can. Now, decking seems to be, especially, I mean, even in this case, State Farm agreed that the decking was part of the roofing system. Now, that's State Farm. Maybe American Family has a different definition of what the roofing system is. Or maybe now, in light of this, you know, all these companies are going to change what their policy is. And so I'm hopeful that the insurance companies will continue to say, you know, now, but here's the question though. If it's a spacing issue versus rotted decking, okay, well, they both need to be redecked, but are they going to say the rotted decking was, I mean, I guess what I'm saying is I don't know. And this case, what it does is it gives the insurance companies the power to narrow and narrow and narrow and narrow. And so hopefully not, knock on wood. But anything is possible. And I do not put anything past the insurance companies as to how they're going to interpret this case and what they're going to either newly deny or change their policy or start to, you know, again, narrow in on things. And so you guys just, you've got to be ready for that decking denial, because it very well could happen. Any other questions for you guys at this time? I've got my email address on here. That's also our phone number. Feel free to jot that down as you ponder things, you know, talk amongst yourselves. You can certainly shoot me an email and I can, you know, to the best that I can, answer your questions. Unfortunately, this presentation is not really a good outline of what to do. It's more of just letting you guys know, I think a shitstorm is coming, and I want you guys to at least be as prepared as you can for what that might look like, because, you know, I think there's going to be a lot of contractors out there. They're not going to have any idea that this happened, and all of a sudden these denials are going to start coming in, and they're going to be in a world of hurt. All right, well, unless there are any other questions, thank you guys so much for your time. I really appreciate you guys joining in. I will make this recording available on our Facebook, LinkedIn, all that stuff. So if you guys, you know, wanted to rewatch it or anything like that, this will be available. But again, thank you all for coming. I really appreciate your time, and have a great rest of your week.
Thank you, Courtney.